Welcome back to the Civil Rights Lawyer channel, where not only do you hear from me, but you also hear from civil rights lawyers who know a whole lot more than I do, and that's what you're going to hear in this video.
And it seems pretty clear that there were several statutory and constitutional violations that were committed by this police force and probably this magistrate judge.
A lot of people have asked me my opinion about this newspaper office raid that occurred in Marion County, Kansas. Was this an illegal, unconstitutional raid? Can a lawsuit be filed? If so, who do you sue? The police? Can the judge be sued? What about YouTube channels? What about citizen journalists? Can they be raided? Well, who better to talk to than Patrick Giacomo of the Institute for Justice, one of the top civil rights lawyers in the country, and also the lawyer who's arguing my judicial misconduct case that I've been involved with here in West Virginia, the family court judge search case, in less than a month in Richmond, Virginia at the Fourth Circuit. Unless you've been hiding under a rock, you saw the news that this small police department in Kansas just straight up raided the newspaper office of this small newspaper and took everything and did a whole lot more. And apparently one of the owners of the newspaper is alleged to have died as a result of it. Everything you need to know about this, as far as a legal analysis standpoint, you are about to hear and more. Let's take a look.
Yeah, I mean, it's obviously everyone is rightly shocked by this incident where basically the entire police force of this tiny town raided not only the local newspaper, the Marion County Record, but the homes of several journalists, including its owner. And then, of course, the tragedy that befell one of the owners. So the owners are a man and his 98-year-old mother, who then, because of the stress of the situation, he alleges, she was otherwise healthy but died the weekend after this raid. And so there's a million different angles of this that are shocking. And the story is very interesting, let's put it that way, because ultimately you have this strange situation where the police executed this multi-pronged search to seize a bunch of computers and notes, not just, by the way, of the local newspaper and its employees, but they also searched, and this I've seen this very underreported, the home of a city councilwoman. And apparently the basis for all of this being done was because this newspaper and the city councilwoman received information pertaining to some DUI conviction that had been secured against a local businesswoman. And next thing they knew, the councilwoman who passed the information along to the town, who I guess at some point was deciding whether to grant this woman an alcohol license, and then the newspaper, which ultimately declined to even do a story on this, all got raided and had a bunch of their stuff seized. And of course, we've seen the aftermath of that. And as you alluded to, now the local DA, who became involved after the fact, from all the reporting I've seen, has basically said there was no basis for the search. They have said they're going to return all the stuff that was taken. But there's a lot more questions than answers at this point. And it seems pretty clear that there were several statutory and constitutional violations that were committed by this police force and probably this magistrate judge.
Seems like one of these small town, typical small town sorts of deals, similar to that case you guys had in Texas.
Yeah, well, that's actually, the thing that kind of sparked in my mind when I saw in the Wall Street Journal about this city councilwoman who was also raided alongside the newspaper, because there's a lot of similarities between that case and our case for Sylvia Gonzalez against Castle Hills, Texas. And those include that, this person had information that the powers that be did not like. And then they sort of cooked up a scheme to get involved without involving the local prosecutor. And they went to a friendly magistrate to get a warrant, and then were able to wreak havoc, which is exactly what happened in our case, Gonzalez versus Trevino or Castle Hills, where the same situation, there's a flimsy basis for some sort of warrant. And instead of involving the local prosecutor, they went around the prosecutor. It got a warrant from a friendly magistrate, then, did in that case arrested our client, in this case executed a search of someone's home, and then will inevitably turn around like they have in our case and say, well, it's not our fault. The magistrate said we could do it. But in this case, it's even crazier because from what I've seen, the application for the search warrant didn't provide any factual basis whatsoever for the search. All it said was, I'm the police chief, and I think there's probable cause to believe that there are some instrumentalities of crimes related to the illegal use of a computer and identity theft. And so I want to search, and then a giant list of every possible thing, physical, digital, forensic, that this newspaper had. And the warrant that ultimately came out of the other end by this judge, magistrate VR, was just a copy and paste job of this application, where the first sentence, instead of saying, I, police chief Gideon, think this, was the judge saying, I have been presented with evidence sufficient to find probable cause, and then copy and pasting the rest of it.
Just setting aside the fact that this was a newspaper newsroom that was raided, just ignoring that fact, do you believe that this otherwise was a valid search warrant based on what you've seen?
No, I think the newspaper aspect of it is what kind of makes it seem more outrageous. And I think that's totally, a justified reaction by a lot of people in the press defense space, and they're right about that. But I think that this was gone about in a completely unconstitutional way because, like I said, everything that I've seen reported and anything else that I've seen, in the news has shown that there was no basis for these warrants to be issued in the first place. I think there's something else going on here that we haven't quite uncovered. There have been a number of motives that have been kind of bandied about in the coverage of this case, but the bottom line is this is not the sort of justifiable warrant process that was envisioned by the founders and to be protected via the Fourth Amendment.
Was this signed by a real judge who had like been to law school and all that, or was this like sort of what we have here in West Virginia, like a magistrate level judge which is just anyone who's elected to the position?
Yeah, so this judge, her name is, I think, Laura VR. She did go to law school. In fact, I found this out because I read a longer article about her, and she actually, as we mentioned earlier, this underlying information and issue has to do with this local business person having had a DUI on her record. This judge herself actually has a DUI or two in her past. And she was a prosecutor in another small town in Kansas for, I don't know, 6 or 8 years before being appointed to this magistrate position. And she was somehow appointed to be the chief prosecutor of the county where she worked 2 years after she graduated from law school. So to answer your question, yes, I mean, she went to law school. She's, for all intents and purposes, a real lawyer, judge. But
so do you believe that this is one of those cases where the judge is to blame, or is this one of these cases where misleading or incorrect information was provided to the judge by law enforcement, and then the judge relied on that?
So I think it's hard to separate the two in this case. I know what you're saying. I don't think that there's anything particularly misleading about what I've seen from the submission that generated the warrant, except for the fact that it was facially inadequate by any basic constitutional standard. So in the Supreme Court, in Illinois versus Gates and others, the court has said, when you are trying to get a warrant and the court is determining whether there's probable cause, what needs to be submitted are statements of fact sufficient to support the existence of probable cause. And the role of the neutral magistrate is to consider those facts and the totality of the circumstances in light of the law that's alleged to have been violated and determine if there's probable cause. And in this case, there are no facts actually alleged. As I mentioned earlier, from what I've seen, what was submitted was just a statement from the police chief that there was probable cause, which is the kind of quintessentially conclusory statement that the Supreme Court has said is definitely not good enough. And so you don't have a situation here, at least that I've seen any evidence of, where the police mislead the judge into granting them a warrant. Here, the police should have known that what they were submitting was insufficient to generate probable cause for a warrant, and the magistrate certainly should have known that what was presented to her was insufficient to support a finding of probable cause that would then support this extremely broad search that, like I said, covered not just this newsroom, but the homes of reporters and the home of at least one city councilwoman. And we haven't seen the formal documents be released yet. I suspect they will be now that the local prosecutor has said that these searches weren't justified. But once we can see those documents, we'll be able to know with much more certainty, exactly what the legal flaws here were. But it's clear at this point that there were a lot of them.
So the newspaper owner, I think, already has said that they want to file a lawsuit. Any chance that the Institute for Justice might be involved in it?
I would love to be involved in it. I can say at this point we're not involved in it, but I do think that with the Institute for Justice's particular specialties involving things like First Amendment retaliation, the Fourth Amendment, our project on immunities, that we're kind of uniquely positioned to challenge a lot of the aspects of this case that might be kind of esoteric or uncommon to civil practitioners. And so we would love to be involved in this case in some capacity. I think there's a lot of pitfalls that involve different forms of immunities or quasi immunities. Like we mentioned earlier, we've got this judicial immunity aspect. You've got the independent intermediary aspect. You've got all sorts of strange little quirks that have to do with the way that search warrants can be secured and then executed. And so I would love to see how we could be helpful in this case, because I do think it's a great illustration of a problem that's otherwise quite widespread. As you mentioned, we've got the case in Castle Hills, Texas, where similar things have happened. We have a case in Louisiana where someone's Facebook post caused them to be charged with terrorism and then raided by a tactical team in Alexandria, Louisiana. We had the case from outside of Cleveland, Ohio, on behalf of Anthony Novak, where he was arrested months after posting a parody of his local police department on Facebook. And so we've just seen these sort of strong arm tactics being engaged in by, local smaller police forces all across the country in enough instances where it's clear to me, at least, that this is something that's quite widespread. And I suspect that the only thing rare about what happened in Marion, Kansas, was that we all found out about it because it became an overnight news story. And thank God that it did.
Just based on what you know now, how difficult will it be to get around judicial immunity if they sue the judge here?
Oh, I think in this case, it would be extremely difficult to get around judicial immunity. And the reason I think that is because, to the extent that we've found ways around judicial immunity, as in our case in West Virginia, it has a lot more to do with arguing that the judge wasn't acting in a judicial capacity when he or she did what she did. And so, there was just this case out of the Fifth Circuit called Rocket versus Amy, where a family court judge, physically arrested some kids. Actually, I think that might be an Eighth Circuit case. And the court said, no, when you actually take the kids and put them in jail, that's an executive role, not a judicial role. You can order people to be jailed, and the courts have granted incredible leeway for those sorts of bad and, in many cases, abusive decisions by judges in their judicial capacity. But so far, the real line that's been drawn by courts is whether you're acting as a judge. And here, I think it's difficult to argue that granting a search warrant isn't an inherently judicial function. It's just a question of whether the judge's actions were so deficient that she was devoid of any sort of jurisdiction for what she did. And I don't know if that standard can be met here, but I think it's a good case to illustrate some of the problems with judicial immunity. And frankly, that is a problem that's exacerbated by things like limits on municipal liability via Monell and qualified immunity. And you've had, very conservative judges like Jim Ho out of the Fifth Circuit explain how there's this sort of unholy trinity of overlapping immunity doctrines that essentially mean that even when someone's rights are obviously violated, there's no one from whom they can seek a remedy. And in that case, I think it was the qualified immunity, Monell, and prosecutorial immunity. But here it's the same dynamic exactly, where it's the police, they can be covered by qualified immunity. They can launder the warrant through the judge who's protected by judicial immunity. And then the municipality can argue, well, this isn't actually a pattern in practice. This was sort of a one-off mistake. And that's sort of the kind of three-step process of avoiding accountability in many instances that are like this one.
Yeah, so here, as far as this case in Kansas goes, this judge is probably going to get out of a lawsuit via judicial immunity because judges are allowed to be completely incompetent so long as they don't do something like really off the wall. Like maybe we'd have to change the facts just a little bit. Like say this judge went to the newsroom and helped in the search.
Yeah,
That would do it.
exactly. Exactly. So if the judge decided to act like a police officer and actually executed the search herself, that would be one of those instances where judicial immunity wouldn't apply, and the courts would say, or at least we hope they would say, well, in this case, you were acting in an executive capacity, not in a judicial capacity. And I think, to the other point that's sort of subtext is that, it's not that judges like this judge get off because of judicial immunity. That's a problem. But the problem is because of that, a lot of attorneys and law firms won't even bring these cases to begin with. And so there are very few cases that really probe into the sort of first principles and the kind of unjustified expansion of judicial immunity that we've seen basically since the 19th century, because people just think, well, look, the courts have pretty much drawn a black letter line here saying you can't sue judges. So I'm not going to waste my time on that, especially if I have a case where there's, plenty of other meat on the bone. And so the result is that judges like this magistrate often just completely get away with it because people don't even find out about it, let alone, is there any chance of liability?
Yeah, the only real remedy probably against this judge is going to be judicial disciplinary complaints or proceedings.
Yeah, and I saw somewhere that someone's already filed some sort of complaint, but I mean, it was just kind of a generic complaint about her behavior in this case, and I just don't know whether that's going to pass muster for the sort of whatever the Kansas system is for judicial discipline.
So that leaves us with what the police chief who signed the affidavit requesting the warrant.
Yeah, you have the police chief, and then you have the police chief also executed the warrant along with apparently the entire police force of this town. So you have all of them, and then of course you also just have the at least the prospect of municipal liability. And then of course, as I think we talked about earlier, you also have the interesting wrinkle here where there is federal law that says that you can't search and seize things from journalists, and if you do, there's actually a cause of action under that federal law, 42 USC 2000 AA, that allows you to bring a cause of action and recover attorney's fees when the search and seizure occurs against, I'm not sure what the actual statutory language is, but essentially, newspapers and similarly like formal journalism.
Yeah, so because this is a newsroom, via that Privacy Protection Act or whatever it's called, federal statute, there is a entirely separate lawsuit aside from Section 1983 where you can sue the municipality.
Right, that's right.
And there's no qualified immunity for that.
Correct. There is, however, a good faith immunity, and it's a little bit confusing. I'm not an expert on this particular statute, but my understanding is, like you said, you can sue the municipality, or if it's a state or federal employee, you can sue them as long as there's not sovereign immunity issues. And if there are, then you can sue the individual officers. And if you're suing the individual officers, they have a good faith immunity where they can argue that they acted in good faith and reasonably, kind of like the old version of qualified immunity that existed between 1967 and 1982. But there, at least in this Privacy Act, it's been codified by Congress as opposed to qualified immunity, which has just been completely made up by the Supreme Court.
My understanding is here that you could sue like a county, you could sue a city, but you couldn't sue, if it was like the state police or whatever they have in Kansas, you couldn't sue the Kansas State Police, or you couldn't sue the state of Kansas because of the 11th Amendment.
Yeah, so I think that's the default, and it could be that there are states, and I frankly have no clue what the law in Kansas is, where some states have waived their sovereign immunity under certain instances, and if that's the case, this statute provides that you can sue the state of Kansas if they were state employees or not. This is all just academic. And if that's not viable, then you can sue the individual officers, I believe is how the statute kind of deals with this problem. But the interesting historical wrinkle here is that the reason why we sue individual officers in the United States is because of sovereign immunity. And it strangely comes out of the concept from English law that the king can do no wrong. And even before the American founding, English courts had interpreted that to mean if the king can do no wrong, someone doing wrong in the king's name must actually be abusing his power as acting on the king's behalf, and so you can sue that person. And so it had already been twisted by Blackstone and others to be like, yeah, you can't sue the king, but you can sue the king's men. Somehow, when we started this country and completely abolished the concept of monarchy, we still kind of unthinkingly carried over this concept of sovereign immunity, which makes no sense in a first principles context for the United States because the people are the sovereign. But because that legal reality occurred, then the solution was often found in having to sue the individual officers, just like in England, it had been suing them because you couldn't sue the king. And so in a roundabout way, like a lot of the complaints people have about being able to sue individual officers as opposed to their government employers is a sort of function of this weird history where there was another immunity that shielded the government employers. And the court said, well, you can sue the individuals. And that's how we get around the concept of denying rights their remedies.
Now, as far as the federal statute that criminalizes searching like newsrooms, I mean, there is an exception to that, right? If criminal conduct is actually alleged against somebody in the newsroom or somebody employed there.
Yeah, that's right. And so, if they were actually committing crimes, and to be clear, the statute also kind of sees how this could potentially be abused and says, except such that the crimes have to do with having the documents, because they could see like, oh, well, we'll say that you can't do this unless there's a crime. And then the immediate response from the law enforcement community will be to say, well, having this document is a crime. And so that's good enough. And the statute says, no, you can't do that. And so you could see instances where, if you're a journalist working in a newsroom and you hack into a bank and steal money to add to your account, that you would not be shielded from a search warrant that would come and seize your computer to produce evidence that you'd committed a crime or something like that.
Do you have any idea what the threshold is for being considered a journalist or a newspaper or whatever under that statute? Like, could that extend to a YouTube channel, for instance?
So the statute does have a definition, and I'm certainly not familiar with it enough to recite it off the top of my head. But I would just refer you to that definition, and I'm pretty sure that it's more circumscribed than a YouTube channel would be enough, or a citizen journalist, which is, as much as I think that journalism deserves protection and the statute at least can be more selective in that way, I do think that there are a lot of misguided attempts at kind of distinguishing between what the government considers to be real journalism and the concept of the press. And this is sort of this weird misnomer where, the media became known as the press because we were referring to them as using printing presses to, disseminate information. But in the Constitution, when you're talking about the freedom of the press, they meant the freedom to use a printing press to print things. And so that's why you see it, you've got freedom of speech to speak, of course, and then you have the freedom of the press, which just means to be able to print things and disseminate them, not because there was some sort of professional class known as the press or professional journalism or anything like that. And so you do see kind of, and we have a case like this actually in Fort Bend, Texas, where our client is a YouTube journalist who has, a YouTube news channel, and he works on all sorts of things, but including police accountability stuff. And he is, very much presenting it in a way that you would see it and think this is, citizen journalism. And there, the police ultimately arrested him and see some of his cameras saying, oh, well, you were at these press events and you're not actually press because you don't work for a professional media organization or whatever. And, our position in that case is like, that's not how the First Amendment works. It might be how this statute works. But I do think this is one of those kind of frustratingly understood aspects of the First Amendment, which is that the press is meant to be much broader than whatever the professional media class is, even though, and this case is a great example, those people absolutely need that protection. Otherwise, we're going to continue to see, small town sheriffs across the country happily smash down the front door of news stations anytime they're getting bad press.
Did you find it?
Yeah, so the way that it's phrased in 42 USC 2000 AA Section A, it says it's unlawful for a government officer to seize work product materials by a person reasonably believed to have a purpose to disseminate to the public a newspaper, book, broadcast, or other similar form of public communication in or affecting interstate or foreign commerce. There's our Commerce Clause hook. And so here, yeah, maybe it is broad enough to cover a YouTuber actually, because the working definition in the first subsection is a person reasonably believed to have a purpose to disseminate to the public a newspaper, that's not YouTube, a book, that's not YouTube, broadcast, that is, I think, or similar form of public communication, that definitely is. So I do think actually this is, appropriately broad to cover, the concept of the press.
Yeah, that might work. I mean, I did have that one case where a federal judge ordered me not to release something on my YouTube channel, and I had briefed the applicability of First Amendment protections to a YouTube channel, and it does apply. But the judge in that case held that his ability to control the release of information prior to the jury trial overcame those First Amendment protections.
Yeah, and that's actually an issue that we've been interested in, and we've seen that happen, in other contexts where attorneys in cases, and this is obviously very important to us because one of the ways that the Institute for Justice, does our public interest or satisfies our public interest goals is by telling people about the litigation we're undertaking and what's happening and why they should care about that. And so I do think there's an enormous First Amendment cost to courts trying to clamp down on the speech of attorneys about their own cases. But yeah, we have seen in many instances the courts will just use their prerogative to control the aspects of cases in front of them to justify silencing people like you from talking about it on YouTube. I do think that presents First Amendment problems. I haven't dug into the specifics on the best ways to untangle that, but it's something I'm very interested in.
So speaking of suing judges and judicial immunity, next month you are going to argue our West Virginia family court judge search case before the Fourth Circuit.
Yeah, that's right. On September 20th, we'll be down in Richmond arguing whether this judge who led a search party through our client's home in obvious violation of the judicial powers invested in her under the West Virginia Constitution is nevertheless able to claim that she has absolute judicial immunity, despite the fact, and I think this is really what makes our case, Gibson versus Goldston, kind of unique among others, despite the fact that the West Virginia Supreme Court in punishing her said that she acted outside of any jurisdiction and she violated her role as a judge and acted like an executive official when she did this. So that's really kind of, I think, what makes our client's case unique is you don't often see things like that. In fact, it's very hard, as you know, and even then, I mean, she was fined a very modest amount by the West Virginia Supreme Court. Of course, there were articles of impeachment that were introduced, but I think there were maybe 10 co-sponsors, but she retired or resigned before those could be ratified. And so, the rarity of this case has to do with the fact that other authorities in the state took action, because that's the thing that you almost never see. And that's kind of like it's similar to cases where, like, we have in our Rosales versus Bradshaw case that we just won qualified immunity issues on in the 10th Circuit. There, the police officer who held our client at gunpoint was actually charged, arrested, and convicted of aggravated assault and child endangerment. And so what makes these cases shocking is just that, hey, there were other mechanisms that actually did impose some amount of accountability. And when that happens, it's kind of a double-edged sword, because on the one hand, the need for accountability via civil litigation, at least in a kind of like thematic way, is slightly less important. But it also goes to show you that there are instances where someone can behave so badly that they would be censured by the state Supreme Court, or they would be convicted of a felony, and then still be able to go into court and say, I should still get immunity, though. Thankfully, not in our case, but in the case out in the 10th Circuit, at least in the District Court of New Mexico, that immunity was applied and then ultimately reversed.
Well, we'll see what happens. I look forward to being there. I'll definitely be there, and I feel good about it. I think we'll win.
I mean, it's like I said, in light of the West Virginia Supreme Court's statements about this judge's behavior in this case, I think that any possible justification for judicial immunity just can't be countenanced by the Fourth Circuit. But these are very important issues because if someone like Matt Gibson can't win a case as egregious as the one against Judge Goldston, then that means that, people down the line, all the way to Kansas are going to run into issues with judges that abuse their power. And that's really kind of the bigger picture issue that we're always sort of trying to focus on at the Institute for Justice, is that these issues are very important to our clients. And that's, always our focus. Our clients always recognize too that these issues go beyond them, because there's not just one person in this country who's being abused by a judge who is violating her constitutional oath. And there's not just one person who's being abused by a police officer who thinks that they're above the law. There are thousands of people. And so if one of these cases can change the law and make sure that there's sufficient accountability such that the Constitution is actually enforceable, the impact of that will be magnified, in 10, 100, 1,000 times.
I appreciate it, Patrick. A lot of great information as always. We'll see what happens here. Hopefully they reach out to the IJ.
Yeah, I would love to talk to the newspaper. They have a private attorney who I think is in Kansas City, Missouri. Like I said, I would love to talk to the editor. I'd love to talk to that attorney and just see how we might be of help, because, as we do handle these cases. We do amicus briefing. We're just happy to consult on these issues because they are very weird and unique. To the extent you kind of leave things on the table, it just is a possibility that, and we see this all the time, that the government will argue, oh, well, sorry, you argued X, Y, and Z, but you should have actually argued A, B, and C instead. Of course, if you argued A, B, and C, they'll say the opposite, but that's the way the game is played.
It's always great to hear Patrick Giacomo's take on something, because this guy is just one of the most brilliant civil rights lawyers out there. So there was a lot of information there, but like I told you, that was everything that you need to know legal analysis wise that's out there so far on this Kansas newspaper raid. And I really think the possible application of this statute to YouTube channels is interesting, something I believe we're going to see a lot more of in the future. I think we're going to see a whole lot more First Amendment litigation pertaining to the new era of journalism that is YouTube, and the new era of government accountability by the people that is YouTube. The Institute for Justice does fantastic work. As you know, if you've watched many of my videos, I always have my own custom donation link in the description of every video, and that is the case with this one. So if you enjoyed Patrick's content, you support his cause, you support the Constitution, I encourage you, donate to the Institute for Justice. Keep Patrick working, and all the other great civil rights lawyers there at the Institute for Justice. They truly are working on your behalf and working on behalf of the Constitution, because there are a lot of people out there who are convinced that freedom is just too scary for them. But freedom is scary. That's just the way it is. Deal with it.